Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This would be our lecture number 105 in the series Indian Polity, and we will continue our discussion on the topic the local bodies, that is Panchayat and the municipalities. In the last lecture, we have started to understand the constitutional provisions. So therefore, the students who are directly coming and watching this particular video, I would suggest you to watch the previous lecture. So for the purpose of better continuity and clarity. And otherwise, students who are planning to prepare for UPSC examination or who are in the process of UPSC examination, for the best benefit of the entire series, or for the best benefit of you, I would suggest you to watch the entire series in a chronological order. So because each and every lecture is logically connected, so that you can understand the next lecture in a better way. So that is how the entire series has been designed. And I'm sure that in the coming years, it is going to benefit lakhs and lakhs of students preparing for UPSC examination, because each and every lecture has been very carefully drafted, taking into consideration that it should give both the conceptual clarity and it should also be presented in a very simplified form. All right, so with that, I'll just continue to the next part. In the last lecture, if you see, I was trying to understand, we are trying to understand about the constitutional provisions with regard to Panchayat and municipalities. We are basically trying to understand as to what the constitution says with regard to the definition of the Panchayat and the municipalities. We try to understand as to what is a Gram Sabha. We try to understand as to what are the structure of local bodies in our country. There is a three-tier structure for the Panchayat and there is different levels of municipalities as well. And what the constitution says with regard to the composition. Who shall determine the composition? The state legislature of each and every state, subject to the law that is made by the parliament. Then we also seen provisions with regard to what is called as reservation of seats. How much seats shall be reserved for women, for the scheduled caste, scheduled tribe, and how at all if the seats is reserved for the other backward caste, how it can be done. So we try to understand, and also the provision of elections, where the elections has to happen every 5 years. And in case of premature dissolution, the election has to happen within 6 months. And such prematurely constituted local body would continue only for the remainder of the term. So anything that you have discussed from the last lecture can be asked in your prelims examination. Definitely one question is likely to come from this particular area. So with that, in addition to whatever we have seen, we'll move to the continuity of that and we'll try to understand the other constitutional dimensions related to Panchayat and the municipalities. So now we are trying to understand as to what is the ground on which a person can be disqualified from being a member of local body or from being contesting elections to the local body. That is again very important. So what the constitution says in this particular regard is a very, very important topic. So let us try to understand. So if you look into the constitution, a person can be disqualified to be a member of local body, that is Panchayat or municipalities, or disqualified from contesting election. If he is disqualified under any election, if he is disqualified under any law for the election to the state legislature concerned. That means, try to understand, this is not directly saying that what is the ground on which a person to contest election to the local body may be disqualified. But it is saying if there is any law, and if that law provides for disqualification of a member of a state legislature or to contest election to state legislature, then all those disqualification will also apply here. So do we have any such law? Yes. We have what is called as a representation of RPA, Representation of People Act 1951. The Representation of People Act 1951 provides for number of grounds for disqualification for someone to contest election to the state legislature. Not only to the state legislature, but also to the Lok Sabha. So if any person is disqualified to contest election to the legislative assembly of that particular state under the provisions of the Representation of People Act, so the same disqualification also apply for a person to contest election to the local bodies. To make it very simple, let me give an example. So one example is, for example, so what is that example? For example, if a person is not a registered voter from any of the constituency in that particular state, if someone is not a registered voter from any of the constituency in that particular state, then he is not eligible to contest election to the legislative assembly. And if he is not eligible to contest election to the legislative assembly, he is also not eligible to contest election to the local bodies. So therefore, whatever is a disqualification to contest election to the legislative body will also automatically apply in case of the local body. So this is what the understanding of this particular provision. I've just given one example, but there are a number of other provisions under the Representation of People Act. Alright, so what are the other provisions that is given in the law? If he or she is so disqualified by under any law made by the legislature of the concerned state. So here in the first provision, if you see, if there is any law and if that law disqualifies anyone to contest election to the legislative assembly of that particular state, then all those provisions will also apply in case of what is called as to contest election to the local bodies. But apart from that, this provision is saying if specifically any law is made by the state legislature of that particular state. If a state legislature of a particular state is making a law and this law is made by the concerned state legislature only for the purpose of what? Only for the purpose of disqualifying members to contest election to the local bodies. So the difference between the first criteria and the second criteria is, well, the first criteria, if there is any law that disqualifies the members of the state legislature, and one such law is the Representation of People Act. But the Representation of People Act is a law that is made by the Parliament of India. So this law can apply in all the states in our country because the law made by the Parliament may apply throughout the country. But however, the second provision is with regard to the law made by the concerned state legislature. If there is any state legislature and if that state legislature makes a law which specifically prohibits a person from contesting election to the local bodies in that particular state, then in that ground also they can be disqualified. So while this can apply throughout the country, this applies only to that particular state. And apart from that, if anybody has not attained 21 years of age, now try to understand, the minimum age requirement for someone to contest election to the Lok Sabha is 25 years, Legislative Assembly is 25 years, Rajya Sabha is 30 years, Legislative Council is 30 years. But when it comes to Panchayat, be it both Panchayat as well as municipalities, the minimum age requirement is only 21. So if someone has not attained 21 years of age, then also they are liable to be disqualified. Otherwise, they are not liable to be disqualified. And apart from all those things, the constitution says if any dispute arises with regard to the disqualification, somebody is disqualified from contesting election, then that dispute can be challenged only in front of such an authority as may be determined by an act of the concerned state legislature. So where they can go and challenge this disqualification, is it in a high court or is it in the district court or any of the other subordinate court or in front of a tribunal? So where they can challenge all those things, who shall specify that? The law passed by the concerned state legislature. So whatever you have discussed with regard to the disqualification in case of Panchayat will apply in ditto to what is called as a municipalities as well. So I'm sure that it is quite clear to all of you. So we'll move forward to the next ground of disqualification. What is the next ground? What is the next constitutional provisions? The next constitutional provision is very, very important as to what is the powers and responsibilities of each and every local body in our country. Or in other words, to what extent the Panchayat and municipality can exercise their powers and functions. Is any powers and functions to the local bodies is directly given by the constitution? Or what is the way by which they can exercise the powers and functions? And to what extent they can exercise these powers and functions. So this is exactly what you are going to understand from this particular constitutional provision. So what the constitution is saying, specifically under Article 243G and Article 243W of the constitution, what is the constitution is saying? So Article 243G is dealing with the powers and responsibilities of the Panchayats. And Article 243W is dealing with the powers and responsibilities of the municipalities. To what extent they can exercise these powers and functions, the constitution makes it very clear. Whatever may be the powers and responsibility that may be exercised by a particular Panchayat, it depends upon the law that is made by the concerned state legislature. So who is supposed to make a law? The state legislature concerned is supposed to make this particular law, and by that law they can delegate as much powers to the Panchayat. So therefore it is very, very important that the Panchayat or be it the municipalities, they do not directly derive the powers from the constitution. The constitution is here and the constitution gives a power only to the state legislature. And the state legislature, based upon the power they get, they can further make a law, and by that law they can delegate some of the powers to who? Either to the panchayats or to the municipalities. So ultimately, who will decide as to what is the power that is exercised by the panchayat or the municipalities? It is based on the law that is passed by the concerned state legislature. So therefore, that becomes very, very important. Okay. So this is what basically you'll have to understand. So therefore, the power that is exercised by the panchayats and the municipalities in different state could be different, because it is actually based on the law that is passed by the concerned state legislature. And if at all the power is conferred upon a particular municipality or a panchayat by a way of a law that is passed by the concerned state legislature, to what extent they can delegate this power to the panchayat and municipalities, there is a limitation for that. So to what extent the power can be delegated? So in case of panchayat, the power may be delegated on all the 29 functional items that is mentioned in the schedule 11 of the constitution. And in case of municipalities, the power can be conferred upon on all the 18 functional items that is mentioned in the schedule 12 of the constitution. So this is basically what you'll have to understand. So therefore, we need to have some basic idea as to what is mentioned in schedule 11 and schedule 12. Some subject matters, 29 functional subject matters or functional items is mentioned in 11th schedule, and 18 subject matters or functional items is mentioned in the 12th schedule. Only in these areas the state legislature can make a law and confers that power upon the concerned panchayat or the municipality. Is that clear to all of you? So in fact, this is one of the biggest problem today most of the local bodies are facing as to why they are not able to function effectively. One of the major criticism being, though the establishment of panchayat and municipality is mandatory, it is a constitutional requirement. It's a mandatory provision. Every state needs to create a system of panchayat and municipalities or the local government institution. But however, what shall be the power of these local bodies depends upon the law that is made by the concerned state legislature. So the basic criticism is that today many states have not conferred this power to the various local bodies. Now, why do you think that the states are reluctant in giving this power to the local bodies? Just think about it. Probably I'll discuss that at a later stage, but just think about this particular question. So this is with regard to the powers and responsibilities. But apart from powers and responsibilities, there is also another important thing that you'll have to keep in your mind, that to what extent the local bodies can have financial powers. That is also very important. There are two important things for anybody to become functional and independent. One is they need to have the power and authority to do certain things. Suppose an individual or an institution is having the power and authority to do certain things, but to carry on and to do certain things, they need to have the finances. They should be in a position to mobilize financial resources. So therefore, they can execute their idea. Therefore, they can execute their plan. So only power and authority is of no use without the finances. Only finances without the power and authority is also no use. So therefore, these two things have to work very closely. And both the things are very relevant for the effective functioning of the local bodies in our country. So what the constitution says with regard to what is called as the financial position with regard to the panchayat and municipalities, that is given under article 243H in case of panchayats and 243X in case of what is called as a municipality. So what the law says in this regard, or what the constitution says in this regard, the constitution again empowers the concerned state legislature to make a law, and by that law they can empower the panchayat and the municipalities to collect the taxes, to appropriate the financial resources. So therefore, the clear understanding you should have, the panchayat and municipalities today in our country is not an independent authority to collect the taxes on their own, and they cannot mobilize any tax or they cannot collect any tax unless and until they are allowed to do so by the law that is passed by the concerned state legislature. Today many panchayat and municipalities collect various types of taxes. Say for example, they collect toll tax, they collect property tax, but the panchayat and municipalities are able to do so because the law that is passed by the concerned state legislature is empowering them or allowing them to do so. So therefore, who is authority to allow the panchayat and municipalities to mobilize their financial resources? It is only the concerned state legislature. So ultimately, the financial powers is also controlled by the legislature of the concerned state. So the powers and functions to do certain things, to come out with certain welfare activities, policies, is also based on the law passed by the concerned state legislature. The financial powers is also based on the law that is passed by the concerned state legislature. So that means unless and until the law authorizes and empowers them, they cannot do anything. So these two provisions are the major criticism today with regard to the functioning of local bodies in our country. The local bodies are not in a position to have their powers. The local bodies are not in a position to mobilize their taxes unless and until it is empowered by the law that is passed by the concerned state legislature. But however, the state legislature has to make a law by which they can empower the local bodies, but for which there is a need for an advisory body which can advise the state government for them to effectively devolve the financial resources from the state government to the local bodies. For this, a specific provision is there in the constitution which allows for establishment of what is called as the State Finance Commission in that particular state. So there is a provision with regard to that also. So what is the constitution is saying? The constitution is saying that after the 73rd Constitutional Amendment Act, within 1 year, the governor of each and every state shall establish what is called as a State Finance Commission. And then every 5 years after that, the governor shall establish what is called as a State Finance Commission. So who is to appoint a State Finance Commission? The governor is the one who will appoint the chairman and the members of the State Finance Commission. We do have a Union Finance Commission, which I will subsequently discuss, but this is in case of the states. So who shall appoint the State Finance Commission? The governor. But the constitution does not say anything with regard to their composition. That means how many members, chairperson should be there in the Finance Commission. That is not given in the constitution. Now, it shall be decided by the law that is made by the concerned state legislature. Not only the composition, but also their qualifications. Their qualification is also based on the law that is passed by the concerned state legislature. So both the composition and the qualifications of the members of the Finance Commission, they shall be determined by the law that is passed by the concerned state legislature. The state legislature makes a law, and by that law they will decide the qualification and composition, and accordingly the governor will appoint the members of the Finance Commission. Now, once the members of the Finance Commission are appointed, what is their function? They shall make a recommendation to the states as to how much money they shall devolve from the state to the local bodies. Now, one is you are directly empowering the local bodies to collect the tax. That is a different thing. That is done by the law that is made by the concerned state legislature. But one is they are directly collecting the resources, but you can also share some of the money that you have. Say for example, there are two ways of empowering an individual. One is you give them some skill, so by the skill he can make his own money. Or in other way is that you can lend that particular person some money. So that is also possible from whatever you have. But in this case, if you see, the Finance Commission will make a recommendation to share some of the revenue that you have to the states. It is not even lending, you will have to share some of the revenue that you have with the local bodies. That means the state governments under the constitution are allowed to mobilize the taxes in the form of taxation. Suppose if the state government collects, let us assume 1 lakh rupees, out of the 1 lakh rupees that they have collected as a tax, they can keep it, most of them for their expenditure, but some of them can be given to the local bodies. And to what extent and what proportion of money from the state government is given to the local government will be recommended by the State Finance Commission. And apart from this sharing of revenue, the State Finance Commission can also recommend for what is called as granting aids, specifically to certain local bodies, not to all the local bodies. This is on top of what has been shared to all the local bodies, certain granting aids. So granting aid means they don't have to give it back. It is a grant that has been given by the state to the local bodies, and to which local body, what type of grant and how much grant can be made shall also be recommended by the State Finance Commission. So these are the major function that is performed by the State Finance Commission. A similar function is also performed by the Finance Commission in case of municipalities. Now remember, there is only one State Finance Commission. The same State Finance Commission performs these functions with regard to the Panchayat under Article 243I, and the same Finance Commission performs these functions, that is to what extent the revenue can be shared to the municipalities and to what extent the granting aid can be given to the municipalities. This function is performed by the same Finance Commission for the municipalities in case of Article 243Y. So therefore, the State Finance Commission is a constitutional body and supposed to perform a very important function under the Constitution of India. So now we will try to understand another important constitutional body which is given in the Constitution is the State Election Commission. So this is again very, very important. So what does the State Election Commission? The State Election Commission is also a constitutional body and it is provided in the Constitution itself by virtue of Article 243K. So why the State Election Commission becomes very mandatory? In fact, if you have seen a couple of lectures back where I talked about the evolution of Panchayati Raj system in our country, many committees were appointed by the government of India and most of these committees have recommended for appointment of what is called as a State Election Commission and also State Finance Commission. The State Finance Commission is basically to give recommendation to distribute the revenue between the center and the states, whereas the State Election Commission is majorly to carry out the election to the local bodies, that is both to the Panchayat as well as the municipalities. So that is basically what is called as the state role of the State Election Commission. So as per the Constitution of India, who is to appoint the State Election Commission and the members of the chairman and the members of the State Election Commission? It is a governor of the concerned state. The governor is to appoint them, and there is one constitutional protection that is given in the Constitution itself for the member and the chairman of the State Election Commission is their service condition shall not be varied to their disadvantage. That means at the time of their appointment, whatever is their service condition, whatever is their salary, whatever is their allowances, whatever is their pension rules, that shall not be varied to their disadvantage. It shall not be reduced to their disadvantage during the term of office. It can be increased, but it cannot be decreased. That's the idea. And further, if you look into the Constitution says that the State Election Commissioner shall be removed in the same manner as that of a judge of a Supreme Court. If at all the State Election Commissioner is to be removed, how he shall be removed? He shall be removed in the same manner as that of a judge of a Supreme Court. Remember, we have already learned a judge of a High Court can be removed in the same manner as that of a judge of a Supreme Court. Therefore, the State Election Commissioner can be removed in the same manner as that of a judge of a Supreme Court. How a judge of a Supreme Court shall be removed? A judge of a Supreme Court shall be removed only on the basis of a motion that is passed by both the houses of the parliament by special majority. And what is the ground on which this motion has to be passed by both the houses? It has to be passed on the grounds of either misbehavior or incapacity. So these are the only two grounds that is mentioned in the Constitution, misbehavior or incapacity, right? So this is basically what the Constitution says. So therefore, if a State Election Commissioner is to be removed, against him also a motion has to be passed in the parliament by a special majority in both the houses. Then finally it needs to be approved by the President of India. So if a question comes, who is the removal authority with regard to the State Election Commissioner? You should not have any doubt the removal authority is the President of India. Though the State Election Commissioner is appointed by the governor, who shall remove him? It is only the President who has got the power to remove him. So now coming to the function of the State Election Commission. Now what is the function of the State Election Commission? The function of the State Election Commission is to carry out election to the state. When I say carry out election to the state, carry out election to the local bodies in that particular state. So they are supposed to carry out the local body election. They are supposed to carry out the Panchayat election, and they are also supposed to carry out the municipal election. That is basically what is their functions. But however, how they shall carry out the elections? They shall carry out elections based on the law that is made by the concerned state legislature. The state legislature of a particular state can make a law, and by that law they can carry out the elections. So this is basically what you'll have to understand. But however, the state legislature is supposed to make a law subject to the provisions of the Constitution. For example, the Constitution says the election to the local bodies has to happen every 5 years. Therefore, the state legislature cannot make a law saying that the elections can held only in every 10 years. That is not possible. Subject to whatever is given in the Constitution, they have to make the laws, and according to which the State Election Commission will carry out elections to both Panchayat as well as the municipalities. So while under Article 243K, they will carry out elections to the Panchayats, And Article 243 ZA, they will carry out election to the municipalities. So that should be quite clear to all of you. Very, very important. So now we are almost coming to the end of the constitutional provisions, the important provisions. Now, how these provisions of Panchayat and municipality shall apply in case of union territories? Will the provisions of the Panchayat and municipalities apply in case of union territories? So, will the provisions of Panchayat and municipalities, will the provisions of first Panchayat, will they apply to union territories? So, for which Article 243L of the Constitution is saying that while the provisions of the Panchayat shall apply to the union territories, so far whatever is seen is in case of the states. But when it comes to union territories, do the provisions of Panchayat apply? Yes. The provisions of Panchayat may apply subject to such modifications and specifications that can be done by the President of India. The President shall specify. This is very, very important. So, therefore, the provisions of the Panchayat and municipalities shall also apply to the union territories. But how it shall apply? Subject to modifications that can be made by the President of India. So, this is what Article 243L is saying. But Article 243L is only talking about with regard to Panchayats. So, which article is dealing with when it comes to the municipalities? It is Article 243ZB. So, will the provisions of the municipalities that you have seen till this point of time, will they apply to the union territories? Yes, they may apply to the union territories, but subject to such modifications that can be done by the President of India. So, therefore, the provisions of Panchayat and municipalities shall also apply to the union territories. But how they shall apply, it depends upon what kind of modifications which is done by the President. The President may make modifications, may not make modifications. But if the President makes a modification, then only in the modified version it may apply to the union territories. So far whatever I have seen, whatever we have seen, in fact, the constitutional provisions right from the beginning of the definition of Panchayat and municipalities, it is almost similar to both the state, both the Panchayat as well as the municipalities. But however, there are last two important constitutional provisions that I am going to discuss, that is Committee on District Planning and the Committee on Metropolitan Planning. These two provisions exclusively apply only to what is called as municipalities. There is no similar provision in case of what is called as Panchayats. So, whatever otherwise I have discussed, we have seen that parallelly how it applies to Panchayat and municipalities. So, the last two constitutional provisions that is there in the municipalities, you will understand it applies only in case of municipalities. There is no corresponding provision in the Panchayat. So, what are they? One is Committee for District Planning or the District Planning Committee. That means for an entire district, as per the provisions of the municipalities, there should be a District Planning Committee. And what is the purpose of this district planning committee as per the constitution? This district planning committee has to determine the developmental plan for the entire district. The district planning committee will collect the developmental plans from various local bodies in that particular district. Whatever local bodies in that particular district, they will collect it and they will consolidate this, and then they prepare a developmental plan for the entire district. And once they prepare the developmental plan for the entire district, they will forward this developmental plan to the state government for the further action of the state government. So, this is what is the function that is to be performed by the district planning committee. However, what shall be the composition of this particular district planning committee? Are they to be elected, or how they are to be represented to this district planning committee? All these things is to be decided by what is called as the concerned state legislature. The state legislature by a law will decide all those things. This is in case of a district. But there are certain metropolitan areas. Say for example, we have big cities like Chennai, Mumbai, Bombay, Kolkata. So, big cities, for a metropolitan area, in case of the municipalities, then there is a need for what is called as a metropolitan planning committee. And what is the role of this metropolitan planning committee? This metropolitan planning committee will consolidate the developmental plan from various blocks within a metropolitan area, and then they will consolidate and they will have a comprehensive developmental plan for the entire metropolitan area and forward this particular plan to the state government. And then the state government can take further action on this developmental plan. So, this is supposed to be done by the metropolitan planning committee. So, for every district there is a district planning committee, every metropolitan area metropolitan planning committee, but these district planning committee or the metropolitan planning committee, This is an exclusive provision only to the municipalities. In case of the Metropolitan Planning Committees also, you'll have to understand that what shall be the composition of this Metropolitan Planning Committee shall be decided only by the law that is made by the concerned state legislature. Alright, so these are all the basic understanding you should have. So if you look very quickly what are the things that you have understood right from the beginning, including the previous lecture also. You have tried to understand the definition of Panchayat and municipalities, what is Gram Sabha. We try to understand the structure of Panchayat and municipalities, composition of Panchayat and municipalities, how the seat shall be reserved, when the election is to be conducted, what is the way that which they can be disqualified, what is the powers and functions that is to be given to the local bodies, what is the financial powers and who will give the financial powers to the local bodies, what is the role of state election commission, what is the role of state finance commission, how these provisions shall apply to union territories, and finally we also seen about the district planning committee and metropolitan planning committee, the last two only the provision for the municipalities and not for the panchayats. Alright, so these are the basic constitutional provisions you should have an idea, and you can expect one question from the constitutional provisions also in your prelims examination, or maybe more questions if you go for other competitive examinations like the state service examination. Therefore, overall if you see, the entire constitutional provisions related to Panchayat and the municipalities in our country, not everything is a mandatory provision. So whatever related to the Panchayat and municipalities, something it is mandatory under the constitution, something is only voluntary under the constitution. Say for example, whatever is to be decided by the law that is passed by the concerned state legislature, it is only voluntary. It is for the state legislature to decide what to be done. But something under the constitution is mandatory. So overall, if you look into the constitutional provisions with regard to Panchayat and municipalities, we can say it is a combination of voluntary as well as mandatory provisions. So before we conclude this particular lecture, it is also important for us to understand as to what are all the voluntary provisions and what are all the compulsory provisions under the constitution. So for example, every village panchayat should have a Grama Sabha, that is a mandatory provision. All the registered voters at the village level of the panchayat constitute the Grama Sabha. There should be a 3-tier panchayat in case of every state. Every state at the apex, there should be what is called as, in fact in every district at the apex, a district panchayat, below that an intermediate panchayat, below that a village panchayat. Direct election to the members at all the 3 levels. Direct election to members in all the municipalities, that's a constitutional mandate. Regular elections, elections every 5 years, that's a constitutional mandate. Reservation for the women, scheduled caste and scheduled tribe, 1/3 reservation for women. Reservation in proportion to population for the scheduled caste and scheduled tribe. That's again a constitutional mandate when it comes to the members. 5-year term, fixed term, that is again premature dissolution means then the election has to happen within 6 months. These are all constitutional mandate. Every state should have a state finance commission. Every state should also have a election commission, state election commission. These are all mandatory under the constitution, be it panchayat or municipalities. But however, apart from all these mandatory provisions, there are also some voluntary provisions under the constitution. So what are the voluntary provisions? Reservation that is given to the other backward caste. If at all any reservation is given to the other backward caste, who shall give the reservation to the other backward caste? It is based on the law that is passed by the concerned state legislature. So this is not mandatory, this is just voluntary in nature. Representation from MPs and MLAs in the local bodies. If you talk of the representation of MPs and MLAs in the local bodies, that means, say for example, let us assume this is a panchayat area. In the panchayat, there are 10 constituencies, let us assume. So this is a village panchayat. In the village panchayat, there are these constituencies. Let us assume 1, 2, 3, 4, 5, 6, 7. Now, let us assume from this particular area, this particular village constituency is also part of a larger MLA constituency. And this can be part of a larger MP constituency. So, right, this is the way it can be. Suppose let us assume an MLA or an MP has elected from this particular area. So he is a resident of this particular area and he has elected as an MLA, or he may be elected as an MP. So now whether to allow this MP or an MLA to be part of the local bodies, he has not won in the local body elections, But from that particular village panchayat, which is also part of a larger MLA constituency or an MP constituency, he has been elected as an MP or an MLA. By virtue of being an MP or an MLA, he will be automatically become part of the local bodies also. Is that possible? Yes. If the state legislature by a law provides for it. So this is not a mandatory provision, but it is a voluntary provision. But apart from that, most importantly, what are the two important voluntary provisions? To what extent the power is conferred upon the local bodies, that is based on the law that is passed by the concerned state legislature. To what extent the finances are conferred upon the local bodies, that is again based on the law that is passed by the concerned state legislature. So therefore, all these provisions are only voluntary provisions, whereas these things are what is compulsory provisions. All right. So with that, we are almost coming to the end of this particular lecture, but we will not complete any lecture without a practice question. So let us try to solve this practice question also. Which of the following are the mandatory provisions under the 73rd and the 74th Constitutional Amendment Act? Regular elections, is it a mandatory provision or a voluntary provision? Reservation to the other backward caste in the local bodies. Reservation to women in the local bodies. Devolution of powers and finances. So which of the following are the mandatory provisions? Choose the correct answer. 1 and 2 only, 1, 3 and 4 only, 1 and 4 only, 1 and 3 only. So you can put your correct answers in the comment box. And please do put your comments, because all your comments are really going to motivate. Ask your doubts also, or you can reach out to me through my Instagram account or through my Telegram account. So don't hesitate to reach out to me. You can consider me as your friend, a mentor or a guide who can help you in this particular examination. My experience of over 15 years as a student as well as a teacher and someone who has cracked this examination multiple times will be of immense use to all the students. So thank you very much. If you like this video, you can share it with your friends and family members as well. All the very best.